I wasn't supposed to be there that Tuesday. I had a property file open on my desk, a cold cup of coffee going cold for the second time, and 17 things I needed to finish before 5:00. But my mother had called that morning, and something in her voice, not panic. She never panicked. Something quieter than panic made me close the file, pick up my keys, and drive 40 minutes across town without really deciding to. I pulled into her driveway at 2:17 p.m. I remember the exact time because I checked my phone while I was still sitting in the car trying to figure out how long I could stay. 30 years of visiting this house, and I'd never once had to think about how long I could stay. I got out, walked up the path, the same cracked concrete path my father had been meaning to repave since 1998. And before I could knock, the door opened. My mother was standing in the frame in her house coat. 93 years old, 4'11", and she had always been a woman who filled a room. That afternoon, she looked small. Her hands were shaking slightly, but I knew her hands, and they did not shake, and she was holding a thick white envelope with the return address of the Maplewood Estates Homeowners Association, printed in navy blue across the top left corner. She looked at me, the way people look at someone when they've been waiting for help they weren't sure was coming. They slid it under the door. For this morning, she said. I didn't want to open it alone. I took the envelope. I opened it at her kitchen table while she made tea she didn't need to make, and I didn't need to drink. The document inside was 4 pages, formal header, numbered paragraphs, signatures at the bottom. It was titled Notice of Formal Removal Proceedings, Unit 14, Maplewood Estates. I read it twice before I said anything. The violations listed were as follows. Item 1, wind chime installed on rear porch, constituting excessive and persistent noise disturbance per Section 9. 4B of the HOA Covenant. Item 2, decorative container plant placed 4.3 and beyond the designated front garden boundary in violation of Section 12.1. Item 3, caregiver vehicle parked in driveway for a period, exceeding the 2-hour limit on 3 separate occasions, violating Section 7.22I. Those were the reasons. A wind chime, a flower pot, a caregiver's car. That was the case they had built against a 93-year-old woman who had lived in this house for 31 years. At the bottom of page 3 in language that was very carefully not casual. Failure to cure all outstanding violations within 30 days of this notice, and failure to remit all acred fines, totaling $1,340, may result in the placement of a lien on the above referenced property and the initiation of foreclosure proceedings as provided under Section 22 of the HOA governing documents. Foreclosure over a wind chime and a flower pot 4 and out of line. I set the document down on the table. I did not crumple it, did not throw it, did not say what I was thinking. I had spent 28 years in property title research. I had read thousands of legal documents. I knew how to keep my face neutral, while my mind was doing something else entirely. My mother put a mug of tea in front of me and sat down across the table. That's when I heard the footsteps on the path outside. I looked through the kitchen window and I saw her coming. Corinne Bellamy, HOA board president, 9 consecutive years, walking up my mother's front path like she owned it, which, as I would later establish in a county courtroom, with documented precision, she absolutely did not. 2 board members walked slightly behind her, the way people walk when they want to look important by association. Corinne was dressed like she had somewhere more significant to be after this. She did not slow down. She did not hesitate. She walked straight to the front door and rang the bell twice hard, even though it was clear someone was home. I answered it. Corinne looked at me the way people look at someone they've already categorized. A quick scan up-down, back to neutral, and then her eyes moved past me to my mother, who had come to stand in the hallway, Margaret. Her voice was pleasant in the way that said it was working at being pleasant. I'm glad you have family with you. I hope you've had a chance to review the board's communication. She still hadn't looked at me directly. I'm her son, I said. I read the notice. I'd like to understand the legal basis for initiating foreclosure proceedings over a $300 parking fine. Corinne's eyes came back to me then. She tilted her head slightly, the kind of gesture that means you're being difficult, and I've dealt with difficult before. Sir, she said, this is an HOA matter, and the bylaws are clear. Your mother has been made aware of the relevant sections on multiple occasions. The board has been more than patient. A pause deliberate measured. I'll be direct with you. This property and all amenities belong to the HOA. Your mother's presence here is no longer welcome under the current terms of compliance. If the violations remain uncured and the fines unpaid, the board has full authority under the governing documents to recover costs through the property. That includes initiating foreclosure if necessary. She let that sit for exactly 1 second. I'd suggest consulting a real estate attorney, though frankly at this stage, it may be too late to change the outcome. The board member on her left, Derek. I'd find out his name later, late 40s, former real estate agent, the kind of man who shakes hands too firmly, actually smiled when she said that. Just slightly, just enough. My mother touched my arm from behind, her fingers light on my sleeve. I just want to stay in my home, she said. Quiet, not dramatic, just the truth of the thing, stated plainly by a 93-year-old woman in her own hallway. She had lived in this house since 1993. She had moved here the year after my father died. She had planted every one of those flowers herself, one weekend in April, in the garden that was now apparently 4 2 wide. The HOA hadn't existed when she bought this property. The wind chime had been hanging on that porch for 11 years. I had listened to it every summer when I came to visit, and I had never once found it excessive. Karen had already turned to leave. The meeting, as far as she was concerned, was over. I folded the notice once carefully along its original crease and put it in the inside pocket of my jacket. We'll be in touch, I said. Karen didn't turn around. After they left, I stood at my mother's kitchen table and looked at the wall beside the refrigerator. There was a framed photograph there I'd seen 100 times and never really looked at a faded survey map. The original plat from when the subdivision was first developed in 1987, mounted in a simple black frame. My father had put it there years ago. I'd always assumed it was just the kind of thing he hung on walls, documents, records, evidence of ownership. He was that kind of man. I looked at it for a moment longer than usual. Then I went and sat with my mother and helped her with the crossword until it started to get dark. What I didn't say, what I had no reason to say yet, because Karen was already gone and none of this had started in earnest, was that I had noticed something in the land description on that survey. Something small, a parcel number. And in 28 years of reading property records, I had learned that the smallest numbers on the smallest documents are almost always the ones that determine everything. Karen had handed me the first piece of paper, in what would become the most expensive mistake the Maplewood HOA ever made. She didn't know, couldn't have known that the ground she was standing on when she delivered that threat. My family's name was on the deed for it. What she didn't know, what none of them knew, was that before the HOA ever poured a single concrete slab on that clubhouse, someone had to sign off on the land. And that signature belonged to my father. To understand what happened, you need to understand what Maplewood Estates had become and what it used to be. When my mother moved in back in 1993, the Homeowners Association was the kind of organization that existed mostly on paper. It held one meeting a year, usually in someone's living room, usually attended by whoever had time on a Wednesday evening. It handled things like petitioning the city for a new stop sign on Birchwood Lane, organizing a community yard sale in the spring, and sending out a one-page newsletter at Christmas with a recipe for pecan pie and a reminder to shovel your sidewalk. It was, by any reasonable measure, a non-event. That version of the HOA was gone long before I started paying attention. Karen Bellamy moved into Maplewood Estates in 2011. 18 months later, she ran for board president. The election was held on a Tuesday night in February. The meeting notice had been emailed 3 days prior, buried in a general HOA digest that most residents had long since stopped reading. 11 people showed up. Karen won by 4 votes. She had, I would later learn when I pulled the meeting minutes, also served as the election's vote counter. In the 9 years since that Tuesday night, she had not relinquished the position. Under her presidency, the HOA governing documents had been revised 3 times. The fine schedule had tripled. When my mother moved in, there were 14 enforceable rules in the covenant. By the time I sat at her kitchen table reading that eviction notice, there were 47. I know because I counted them. Rules covered everything from the approved palette of front door paint colors, 8 options listed by brand and code, to the maximum height of decorative grasses to the specific type of garbage. Container lid required for compliance. Each rule carried a fine. Several fines were structured to accrue daily. In 9 years, 2 families had sold their homes and left rather than keep fighting. The Petersons, 2 doors down from my mother, received a lien notice over an unapproved garden shed. They paid $3,200 to a lawyer to have it resolved, then listed the house 6 months later. The GARC, as on the east side of the development, had a fence dispute that ran 14 months before they quietly settled and moved to Phoenix. The rest of the neighborhood had learned to be very, very careful. Not happy careful. There is a difference. And it shows up in the way people talk to each other in driveways, in the way conversations stop when certain subjects come near. I saw it clearly when I started asking questions. The first thing I did the morning after visiting my mother was request a copy of the HOA's original founding documents from the county clerk's office, the ones filed when the association was formally incorporated in 1998. I had them in my hands by early afternoon. There were 42 pages of standard HOA boilerplate, but I read them the way I read every document, looking for what wasn't there as much as what was. The land description in the common area section was in the language of someone who does this for a living. Loose. It referenced all common parcels as identified in the Maplewood Estates Plat Phase 1, without listing specific parcel numbers. It was the kind of language that makes a title examiner's eyes narrow, because it assumes the plat says what you think it says without anyone actually checking. I photographed every page and put them in my Maplewood folder. That same afternoon, I drove back to the neighborhood and knocked on Ray Kowalski's door. Ray was a retired high school history teacher, 70s, lived 3 houses down from my mother since 1999. The kind of man who remembers the exact year everything happened and tells you whether you ask or not. I had always liked him. I asked him about the clubhouse. There was some confusion back then, he said, standing in his driveway, keeping his voice at the level people use when they're not sure who might be nearby. About that strip of land, who owned it? I remember because someone raised it at a meeting. This was 2001, maybe early 2002, and Corinne's predecessor just kind of waved it off. Said the paperwork was being handled, and then the clubhouse went up and nobody asked again. He paused. Why are you asking? I'm trying to understand the full picture, I said. He looked at me for a moment. If you ever need someone to say what they remember about that meeting, he said carefully. I still have my notes from it. I always took notes. I told him I'd keep that in mind. I meant it more than he knew. I also talked to the Hendersons, Patricia and Tom, mid-60s, both retired, who'd been in Maplewood long enough to remember the old HOA. Patricia looked left and right along the street before she said a word, then told me quietly about an unapproved deck extension 2 years prior, a bylaw that had been revised without announcement 4 months before Tom submitted his plans, and 8 months of legal back, and fourth that ended in a $4,000 settlement check they could not afford. We can't go through that again, she said. I'm sorry. I hope your mother is all right. I genuinely do, but we cannot be involved. I told her I understood. I meant that too. When the cost of resistance is set high enough, silence becomes a rational choice. Corinne had understood that from the beginning, and she had built her system around it. My mother had first appeared on Corinne's radar 2 years before the eviction notice over a garden statue. A small stone cint, Francis of Assisi 14 and worn smooth by weather, sitting in the front garden since 1997. It had been there through 4 HOA presidents, through 2 renovations of the common area, through 26 years of seasons, and no one had ever said a word about it. Corinne mentioned it in a certified letter citing unapproved decorative structure section 14.3. My mother wrote back politely and said she would not be removing it. That letter, I would eventually understand, was the moment Corinne decided that Unit 14 was going to be a project. From there, violations appeared with a regularity that wasn't coincidental. Every 2 or 3 months, a new letter, each one technically arguable, none of them individually worth a 5-figure legal fight. That was the architecture of it. Not one clean blow, but a slow accumulation of small ones, each designed to either wear you down or give you enough paper to build a formal proceeding. My mother was 93 years old and living alone on a fixed income. Karen had, I think, calculated that correctly. She had not calculated on me. That night, back at my own kitchen table, I spread out the contents of the folder I'd taken from my mother's filing cabinet, the one from my father's estate that I'd been meaning to go through for months. Insurance papers, a tax assessment from 2009, a warranty deed from the original purchase, and underneath all of it, a land survey, the original plat map from 1987, the year the subdivision was first developed. My father's handwriting was in the margin. Parcel 7C, acquired March 1989. I set it next to the HOA founding documents I'd pulled that morning. Specifically, the page with the loose common area description, the one that referenced the plat without listing parcel numbers. I looked at both documents for a long time. I had been reading property records for 28 years. I knew what happened when a land description was vague, when the numbers didn't match up with what was sitting on top of them. I took a photograph of my father's notation, attached it to the HOA founding docs, and sent everything to my attorney with one line of text. "Can you look at something for me tomorrow?" Then I opened my phone's camera and began photographing every HOA notice stacked on my mother's kitchen counter. Each one dated, each one signed by Karen, and added them to the folder. I'd labeled Maplewood. I didn't know the full shape of it yet, but I had been doing this job long enough to know that when a parcel number doesn't match, something in the entire chain above it is built on a mistake. The question was how far up that chain the mistake went. The first new fine arrived on a Thursday. 3 days after Karen stood on my mother's front path and told her she was no longer welcome in her own home. I was at my desk when my mother called to read it to me over the phone. Her voice was steady. She had always been steadier than most people half her age, but I could hear the careful way she was choosing to be steady, which is different from actually being steady. The notice cited caregiver vehicle parked in driveway in excess of permitted 2-hour window. 3 separate occurrences, section 7.2 AA, $200 payable within 14 days. I told her to put it on the kitchen counter. I'd pick it up when I came by. I came by 3 days later, and there were 3 of them. The second had arrived the day after the first, $150 for garden hose stored on front porch in visible condition, constituting an eyesore in violation of section 11.7. My mother's garden hose, the one she used to water the flowers she'd planted herself in 1993. The third notice was the one that made me sit down. $300 for unauthorized modification to existing structure. Section 16.2, a front entry handrail repainted without prior written board approval. My mother had hired a handyman to repaint the handrail in June. The handrail she used every single day because she was 93 years old and needed it to get in and out of her own house safely. The color was identical to the original. Same paint brand, same finish, same shade. She had simply not submitted a written approval request to the HOA board beforehand because it had never occurred to her, or to any reasonable person alive, that repainting a safety handrail the same color it already was would require a formal application to a 9-member volunteer committee, $300. I laid all 3 notices on the table next to the original eviction notice and added them up. In 10 days, the outstanding fine total had gone from $1,340 to $1,990. I photographed each notice individually, front and back, with timestamps. I built a spreadsheet that evening. Date received, violation cited, section referenced amount, cumulative total. 28 years in property title research had given me certain habits, and one of them was that you document everything before you understand why it matters. Because by the time you understand why it matters, it is sometimes too late to go back and document it. I was at my mother's house the following Tuesday when Derek came to the door. He didn't knock. He rang the bell 3 times in quick succession. The way people ring when they've decided the person inside is already taking too long. I answered it. Derek was standing on the step with a manila folder tucked under one arm and the expression of a man who considers himself to be delivering news from a higher authority. Late 40s former real estate agent was my first read. Something in the way he assessed the doorframe before he made eye contact. He didn't greet me. He opened the folder and produced a single document. The board requires a formal written response to all outstanding violations within 72 hours. He said, if a response is not received, the fine accrual structure converts to a daily rate. He held out the document. This outlines the timeline. I took it. The daily rate was $50 per active violation. 3 violations, $150 per day, beginning at the end of the 72-hour window. The document was signed by Karen. Below her signature, the board wishes to remind the unit owner that proactive compliance is always preferable to enforcement proceedings. I looked up at Derek. Thank you, I said. He held eye contact a beat too long. A small performance of authority, then glanced past me into the house. Then he turned and walked back down the path. I closed the door and stood in the hallway for a moment. My mother was in the kitchen. I could hear the radio. I folded the compliance timeline and put it in my jacket pocket alongside the original eviction notice. The county code inspector arrived 2 days later. I learned afterward that Karen had filed a formal complaint with the county's residential compliance office requesting an official inspection of my mother's property. His name was Jim Watts, a heavy-set man in his late 50s, clipboard, reflective vest, the practice neutrality of someone who does 8 of these inspections a day. He walked the perimeter, checked the front garden, looked at the handrail, peered at the porch. My mother made him coffee, which he accepted without making it awkward, which told me something about him. When he was done, I walked him back to his truck. He flipped through his clipboard notes without looking at me and said, in the flat tone of a man choosing his words carefully, between you and me, most of these citations are a stretch. The handrail is structurally sound. The garden hose is a garden hose, and the caregiver parking situation falls well within what I'd normally call reasonable use. He finally looked at me. I'll write up what I saw, but I want you to know what I saw. I thanked him. I took his card. I wrote his name at the top of a separate page in my notebook and underlined it. That evening, I called Lisa, my attorney, a real estate specialist I had worked alongside on complicated title cases for the better part of a decade. I described the situation. Aging parent, HOA pressure campaign, escalating fines, inspector already dispatched, lien threat coming. She asked 2 questions. The first was whether I had the HOA's original founding documents. I said I did, and that the common area land description was vague in a way that bothered me. The second question was whether I had the original plat map for the subdivision. I said I had it, and that there was a parcel number in it I wanted her to look at. Send everything, she said. I sent it all that night. The HOA founding documents, the plat map with my father's notation, the fine notices, the eviction letter, the compliance timeline, Derek's daily accrual schedule. I also ordered a doorbell camera for my mother's house and installed it the following morning. If people were going to keep showing up at that door, I wanted a precise record of when they came, what they did, and exactly how they left. On Thursday, Karen sent a community-wide notice, posted on the bulletin board at the Maplewood entrance, and emailed to all 96 homeowners. The board reminds all residents that HOA covenants exist to protect the investment and quality of life of every homeowner in our community. Enforcement is applied equally and without exception. Residents with outstanding violations are encouraged to seek compliance promptly. It didn't name my mother. It didn't need to. Within an hour of that email going out, I had received 3 separate messages from neighbors. Each one sympathetic, each one carefully worded. None of them offering to say anything on the record. I understood. I thanked them. I added their names to a list not of people to pressure, but of people who might, if the situation ever became safe enough, choose to speak. 2 days later, a certified letter arrived at my mother's address from the HOA's legal counsel. It confirmed that a board meeting had been scheduled 3 weeks from that Friday to formally address the outstanding violations. It also stated clearly that if the total acred fines were not paid in full prior to the meeting, the board would proceed with filing a lien against the property. The second paragraph used the phrase foreclosure as a remedy of last resort. There was a footnote. I sat with my mother that evening for a while. She asked me directly if she was going to lose the house. I looked at her. No, I said. You're not. She studied my face for a moment, the way she had always looked at me when she was deciding whether to believe something, and then went back to her crossword. I drove home and opened the folder on my kitchen table. Lisa hadn't called yet, but the pieces were arranging themselves the way they do when you've been doing this long enough to recognize the shape of a thing before you can prove it. The plat map, the founding documents, the parcel number in my father's handwriting, Jim Watts's card sitting on top of the stack. 3 weeks until the board meeting, 2 weeks until the lien filing deadline, and somewhere in that folder, a land survey from 1987 that was about to change everything. About this situation, I just didn't know yet exactly how much. Lisa called me on a Tuesday morning, 4 days after I'd sent her everything. I was in my car about to pull out of a gas station, parking lot, when my phone lit up with her name. I had known Lisa Carver for 11 years. We had worked through title disputes together, boundary conflicts, easement cases that took 2 years to untangle. I knew her professional voice the way you know the sound of an engine running differently than usual. Not wrong. Exactly. But changed. This was different. Where did you get these documents? She said before I'd finished saying hello. I told her my father's estate folder, the plat map on my mother's kitchen wall, the county clerk's office for the HOA founding docs. There was a pause, 3 seconds, maybe 4. I need you to come in, she said, today if you can, and don't discuss any of this with anyone until we've talked. I was at her office by 1:00. She had the documents spread across her conference table when I walked in. The 1987 plat map, the HOA founding documents, and a fresh county assessor printout she had pulled that morning as a cross-reference. She had drawn a red circle around a parcel number on the plat and written 2 words in the margin. Check this. She didn't sit down. She stood at the head of the table and walked me through it the way she always walked me through things, methodically. No editorializing until the facts were fully on the table. The Maplewood Estates subdivision had been developed in 1987. When it was platted, the land was divided into residential lot streets and common areas. The common areas were supposed to transfer to the HOA when it incorporated in 1998. Most of them did. The transfers were routine, properly recorded, clean. Most of them. Parcel 7C was a small lot on the southern boundary of the development, irregular shape, just under half an acre, bordered on 2 sides by residential lots, and on the third by the community green. According to the 1987 plat, it was designated as a private lot, not common area, not HOA property, a private lot that happened to sit at the geographic center of the neighborhood. My father had seen that designation in 1989. He had purchased parcel 7C from the original developer for $14,000. A modest investment held quietly, never developed. When he died in 2014, it passed to me through his estate. I drove to the county assessor's office that afternoon in person because I wanted to hold the document myself and pulled the full deed history for parcel 7C. The clerk brought out the file. I photographed every page, and the clerk made me a certified copy with the office seal. My name was on the current deed. The title chain was unbroken from 1987 to the present. There were no encumbrances, no disputes, no competing claims of any kind. That certified copy became what Lisa and I would later refer to as Exhibit A. And on top of parcel 7C, the Maplewood HOA had constructed their clubhouse in the spring of 2001. Lisa finally sat down. They built on land they don't own, she said. The clubhouse, the meeting rooms, the pool equipment room, the parking area adjacent to it. All of it sits on your parcel. They've been collecting dues for 23 years to maintain a building that is sitting on private property. Your private property? I looked at the plat. I looked at the assessor printout with my name at the top. I had suspected something since the night I first spread these documents on my kitchen table. Suspicion is one thing. Confirmation delivered by a real estate attorney who does not use words loosely in a conference room with the documents. Side by side is something else. Can I give them a deadline? I asked. Lisa looked at me steadily. You can do a lot more than that, she said. She laid out the options. I could send a formal notice of ownership immediately. The lien would evaporate overnight. Corinne's board would panic and it would be over fast. Or I could file a title dispute with the county court before the board meeting, stay the lien automatically, and force the entire matter into a public legal proceeding on the record. The second option meant waiting. It meant letting the lien get filed, letting Karen walk into a courtroom fully confident, and letting the reversal be total and documented and impossible to minimize. I thought about Patricia Henderson. $4,000, 8 months. We can't go through that again. I thought about the Petersons who sold the Garcas in Phoenix. I want them to finish, I said. I want everything they've done to my mother on the record before we show them anything. Lisa nodded. Then we wait, but we use the time well. I left her office with a plan and a manila folder containing copies of the deed, the plat map, the certified assessor printout, and the probate record from my father's estate. All the documents establishing the unbroken chain of ownership from 1987 to my name. The originals went into a fireproof box in my home office that evening. The following Thursday, I was loading groceries into my car in the parking lot of the Kroger on Birchwood when someone knocked softly on my passenger window. Carol Reyes, 62, silver street hair, elementary school art teacher. I knew her by sight from years of community events. She was standing close to the car, not quite hiding, but not in the open either. When I lowered the window, she looked left, looked right, and held out a manila envelope with both hands. I heard you were asking questions, she said quietly. I've been waiting 3 years for someone to ask. Inside the envelope was a document stack, approximately an inch thick. I sat in the car for 20 minutes going through it while Carol waited, arms folded, watching the parking lot. 3 years of HOA correspondence, fine notices, compliance demands, a formal lien threat from 2021, all stemming from a retaining wall Carol had built to prevent soil erosion on a sloped section of her backyard using materials she'd been verbally told were acceptable at an HOA pre-approval meeting. She had paid the fines $6,000 total over 14 months because the alternative was a legal fight she could not afford on a teacher salary with a mortgage still running. But the last item in the envelope was something different. It was a printed email chain, dated 8 months prior between Karen and Derek. Karen was discussing a pergola she was having built in her own backyard. The pergola, as described in the email, required the same category of structural modification approval that Carol's retaining wall had required: a formal application, a board vote, written confirmation. In the email, Derek replied to Karen's informal note, noted, "No further action needed on your end." Carol had obtained the email through a public records request. Under the state's applicable disclosure provisions, HOA board communications were subject to public access. She had done this quietly on her own 3 months ago and had been sitting on it ever since, not knowing what to do. She fined me $6,000 for following a process she completely skipped for herself. Carol said, "I have everything: the dates, the amounts, the before and after photos. I just couldn't do anything with it alone." I told her that was about to change. I took the envelope. I told her to keep copies of everything at a location outside her home and to contact me if the HOA sent her anything new in the coming weeks. Over the following days, I quietly reached out to 7 homeowners I had identified through the pattern of fine notices. 5 agreed to provide written statements. 2 declined. 1 said nothing. 1 told me with real regret that they had elderly parents of their own and couldn't risk a retaliation campaign. I did not push either of them. I now had a folder that had grown well beyond its original size: the deed, the plat, the certified assessor printout Exhibit A, the probate record, Carol's complete file, including Karen's email, 5 neighbor written statements, Inspector Watts's card, and his verbal assessment written up in my own notes. Every fine notice issued against my mother, photographed, dated, and entered in a spreadsheet. 9 days until the lien filing deadline. 13 days until the board meeting. Karen had spent 9 years building a system on the assumption that no one would ever accumulate enough to fight back, that the cost of resistance would always exceed the cost of compliance, that people like my mother, elderly, alone on a fixed income, would absorb what was done to them because the alternative was too expensive. She had not considered the possibility that someone had been quietly holding the deed to the ground her entire operation was built on. The lien was filed on a Thursday, not the Friday Karen had specified in her certified letter, not at the end of the formal window she herself had set. 2 days early, without additional notice, without a final courtesy call, I found out the way my mother found out: through the bank. She called me at 7:42 in the evening. Her voice had the particular quality of someone trying very hard to sound like they are not frightened. She said the bank had left a message about a legal hold flag on her account, something to do with the property, and she didn't understand what it meant, but the word legal was in it, and she thought I should know. I told her I would look into it and call her back within the hour. Then I opened my laptop and pulled up the county property records port, the same database I used professionally, the one I had logged into thousands of times over 28 years. I typed in my mother's address. The lien was there. Filed that afternoon at 3:17 p.m., recorded in the county's public records, attached to the deed for Unit 14, Maplewood. Estates creditor, Maplewood Estates Homeowners Association. Amount, $1,990 in outstanding fines, plus an administrative filing fee of $340. Total encumbrance on the property, $2,330. Public record. Anyone searching that address would see it. I sat with that for a moment, not with anger. I was past the point where anger was useful, but with a precise kind of attention. They had filed 2 days early. The letter from their legal counsel had specified a deadline, and they had not honored their own deadline. That was a detail, small on its own, but details accumulate, and I had been accumulating them since the afternoon my mother opened her front door holding that envelope. I called my mother back and told her the lien had been filed, that it was a legal instrument designed to pressure rather than to harm, and that it would be addressed. I told her again that she was not going to lose her house. She said quietly that she trusted me. I said good night and sat at my kitchen table for a long time after that, because being trusted by your 93-year-old mother to fix something like this has a weight to it that is difficult to describe. The doorbell camera notification came through at 7:14 the following morning. I was still at home, coffee in hand, when my phone buzzed with the motion alert. I opened the footage. Derek was on the path, walking quickly. No briefcase this time, just a single folded document in his right hand. He reached the front door. He did not ring the bell. He did not knock. He unfolded the document, pressed it flat against the door with one hand, and taped it into place with 3 strips from a roll he pulled from his jacket pocket. His face was clearly visible in the frame. The camera angle, the morning light. He stepped back, looked at what he'd done, and walked away without once looking up. In the frosted glass panel beside the door, barely visible, there was a silhouette, my mother, standing in the hallway in her house coat, watching him through the glass. She had been awake. She had heard him on the path. She had stood there in her own house and watched a man tape a foreclosure notice to her front door without so much as knocking. I saved the footage to 2 separate locations before I did anything else. The notice Derek had posted was a formal foreclosure timeline, the sequence of steps the HOA intended to pursue if the lien remained unresolved after the board meeting. It was thorough, and it was written to intimidate, which it was designed to do. I photographed it, added it to the Maplewood folder, and then made a decision I had been considering for 2 days. I drove to the county records office not to file anything, not yet to pull paper. The county records office maintained physical archives of every construction permit, every plat map filing, every recorded meeting minute from every incorporated entity in the county going back decades. I had spent more hours in rooms like that one than I could estimate. I knew the archivists by first name. I knew where things were filed and how to ask for them correctly. I requested 4 items. The original 1,987 plat map for Maplewood Estates, the 2001 construction permit for the Maplewood HOA clubhouse, the board meeting minutes from the period covering the clubhouse approval and construction, and the complete deed history for parcel 7C from 1,987 to present. The clerk brought everything out in 2 folders. I sat at the research table, spread the documents out, and began working through them systematically. I photographed each page before I read it, so I had the images regardless of what I found. The 1,987 plat map I already knew. Parcel 7C private lot, southern boundary, just under half an acre. My father's name in his own handwriting in the margin of his personal copy. The county's official version was identical in every relevant particular. The 2001 construction permit was next. It authorized the construction of a community clubhouse facility on behalf of the Maplewood Estates Homeowners Association. It referenced a site plan attached as Exhibit B. I turned to Exhibit B. The site plan showed the clubhouse footprint, the parking area, the utility connections, and in the lower right corner in the standard notation box, where the parcel designation was recorded, HOA Common Area Parcel 6D. I looked at that number for several seconds. Then I pulled out the deed history for Parcel 7C and set it next to the construction permit. The physical location described in the construction permit site plan. The GPS coordinates, the boundary measurements, the adjacent lot numbers corresponded precisely to the location of Parcel 7C on the 1987 plat. The clubhouse was physically demonstrably sitting on Parcel 7C, but the permit said Parcel 6D. I pulled the deed history for Parcel 6D from the General Index. Parcel 6D was an HOA common area lot on the north side of the development, a green space near the entrance, used for landscaping nowhere near the clubhouse. It was correctly deeded to the HOA in 1998. It was empty, no structures, no construction. It had always been empty. Someone in 2000 and one had transposed two numbers, 6 and 7, D and C1 digit 1 letter. And in the 23 years since no one, not the HOA's legal counsel, not their title insurance carrier, not a single board president, including Karen, had ever gone back to verify that the number on the construction permit matched the number on the deed. I sat at that research table for a few minutes without moving. In 28 years of title work, I had seen errors like this, not often, but I had seen them. A transposed number in a land description is the kind of mistake that gets buried under everything built on top of it, literally and legally, until someone goes looking. I photographed everything: the plat, the permit, the meeting minutes, the full deed history. I had the clerk make certified copies of the construction permit and the meeting minutes stamped with the county seal and the retrieval date. I paid the copying fee in cash and tucked the folder under my arm. I called Lisa from the parking lot. She called back 11 minutes later. I read her the parcel numbers from both documents while she pulled up her own copies. There was a silence on her end that lasted long enough that I checked to make sure the call hadn't dropped. They built on the wrong parcel. She said the construction permit, the title insurance they presumably carried at the time, the HOA's own meeting minutes, all of it references the wrong number. The clubhouse has been sitting on private land for 23 years, and every single governing document the HOA has produced in that time is based on a parcel designation that was wrong from the day it was filed. Another pause. The lien they filed yesterday. It is going to look absolutely spectacular in front of a judge. I thanked her, told her I'd messenger the certified copies to her office that afternoon, and ended the call. Then I drove to my mother's house. She was in the kitchen when I got their radio on, working on a letter to her sister. She looked up when I came in. She didn't ask about the lien, about the notice Derek had taped to her door that morning, about any of it. She poured me coffee without being asked, and we sat together at the kitchen table, and I helped her finish the letter. Before I left, she asked me, not for the first time, but more quietly than before, if everything was going to be all right. I looked at her at the framed plat map on the wall behind the refrigerator at the St. Francis statue visible through the kitchen window, sitting in the garden in the late afternoon light, exactly where it had been for 26 years. Yes, I said, everything is going to be all right. I meant it in a way I had not been able to mean it before that afternoon. The lien had been filed on a Thursday. The HOA board meeting was scheduled for the following Tuesday, and Karen had just made the last move she would ever make as president of the Maplewood HOA. She just didn't know it yet. The Maplewood Estates Community Center meeting room held approximately 40 chairs when they were set up in rows, which they were that Tuesday evening. By 7:00, 34 of those chairs were occupied. I stood near the back for a few minutes before I sat down just to look at the room. I had learned early in my career that the way people arrange themselves in a space tells you things about the situation before anyone opens their mouth. The front 2 rows were empty. No one wanted to be that visible. The back rows had filled first. People had come in pairs, mostly sitting close together, speaking in voices that stopped when someone new walked in. Ray Kowalski was there, 3rd row from the back, with a small spiral notebook on his knee, the same kind he'd probably carried to every meeting in this neighborhood for 25 years. Carol was there, seated toward the middle alone, her coat folded precisely on her lap. The Hendersons were in the far corner near the door, Patricia's hand resting on Tom's arm. A young couple I didn't yet know sat near the aisle with a manila envelope, a child's drawing inside it. I'd find out later. Lisa was already in the front row on the right, leather portfolio open, pen in hand. The board table was at the front, folding tables, pushed together, covered with a tablecloth that was trying harder than the room deserved. Corinne sat at the center, Derek to her left, two other board members to her right. Corinne was in a blazer. She had a water glass, a legal pad, and the collected posture of a person who has run this meeting 9 times and sees no reason the 10th should be different. She called the meeting to order at 7:05. She opened with a prepared statement. I counted the word unfortunately 4 times in the first 3 minutes. Unfortunately, despite repeated communications, unfortunately, the board has no discretion when covenants are in violation. Unfortunately, at this stage, the matter has required formal action. It was a performance of reluctance. She never used my mother's name. She referred to the property as Unit 14 throughout the way you refer to a file rather than a person. She described the violation history as a pattern of noncompliance spanning 18 months and the lien as a standard enforcement mechanism available under Section 22 of the governing documents applied equitably across all properties. She did not mention that my mother was 93 years old. She did not mention the wind chime. Public comment was opened. Carol stood first. She didn't shake. I had half expected her to. She had been sitting on this for 3 years, and a room with 34 people in it was not the Kroger parking lot. But she stood straight, held her papers at a readable angle, and began. She cited 3 specific instances. First, her retaining wall, 2021, verbally pre-approved. Fined anyway, $6,000 paid over 14 months. Second, a neighbor cited for a decorative flag during a national holiday, while an identical flag 2 streets over went unsighted for 6 weeks. Third, an email dated 8 months prior, in which Corinne had confirmed to Derek that her own backyard pergola requiring the same formal approval process Carol's retaining wall had required had been handled with a private internal note and no board vote whatsoever. She read the relevant line aloud, noted. No further action needed on your end. The room went quiet in a specific way. Not the quiet of boredom, the quiet of people hearing something said out loud that they had long suspected, but never seen documented. Corinne's pen stopped moving. Ray stood next. He had his notebook. He spoke about the 2001 clubhouse construction meeting. He had attended it. He had taken notes, and a question had been raised at that meeting about the land designation for the construction site. Whether the parcel had been properly verified as HOA common area before the permit was filed. The then president had waved it off, said the paperwork was being handled. Rai said he still had those notes and would make them available to any party that requested them. Corinne thanked him for his comment with the pleasant precision of someone putting a lid on something. The Morales family went next 2 streets over. $400 fine for a child's basketball hoop in the driveway for 48 hours while their son was home from college. The wife read from a prepared statement. The husband held the envelope with the drawing. 2 more residents followed, one about a noise citation during a child's birthday party on a Saturday afternoon. One about a holiday wreath fine after a deadline that had been moved up 2 weeks without notice. 5 people, 5 different violations, 5 different properties and years. 1 signature at the bottom of every notice. When Corinne moved to close public comment, Lisa stood before she could speak. Lisa introduced herself and her firm. She stated that she was formally entering into the public record a written assessment from James Watts, County Residential Code Compliance Inspector, regarding the violations cited against Unit 14. She read the key finding of 11 violations cited. 7 fell within normal tolerance ranges and would not typically result in formal citation. Mr. Watts described the enforcement as disproportionate relative to comparable properties in the community. She then stated that she had earlier that afternoon filed a formal title dispute with the county civil court regarding the land parcel on which the Maplewood Estates clubhouse had been constructed. Under applicable state law, the filing automatically stayed the lien against Unit 14 pending resolution. The lien was legally suspended effective immediately. A court hearing had been scheduled 21 days from today. She said all of this in the same tone she would use to read a grocery list. Calm, sequential, final. The room shifted, not loudly. A few murmurs at the edges, a couple of people turning to each other. Corinne's legal pad was very still on the table in front of her. The HOA's retained attorney leaned forward and said that the title matter was not properly before this meeting and that the board's position on the lien remained unchanged pending any court determination. Then I stood up. I didn't have notes. I'd like to ask the board one question. I said before the HOA constructed the clubhouse on this property in 2001. Did the board obtain and record a clear title on the land it was built on? Corinne looked at me, not past me, not through me at me, directly for the first time. That's not relevant to tonight's proceedings, she said. I think it might be, I said, but I'll let the county court decide. I sat down. The attorney leaned toward Corinne. She listened, nodded once, and then looked at the room with the expression of someone who has just changed the calculation she's been running. She announced a move to close session to confer with legal counsel and closed public comment. People began to move toward the door. Ray stopped next to my chair and said quietly, "Good." Just that. Carol touched my shoulder briefly as she passed. I stayed until most of the room had emptied. Near the front, Derek was leaning close to Corinne, speaking in a low voice. She listened. Then she turned and looked across the room toward where I was sitting. It held for a few seconds, long enough to read. I had spent nearly 3 decades watching people's faces across conference tables, and I knew the difference between someone who is simply angry and someone who has for the first time begun to understand the actual size of the problem. Standing in front of them, what I saw on Corinne's face in that moment was not anger. I picked up my jacket, said good night to Lisa, and walked out into the parking lot. 21 days until the hearing, and I still hadn't shown them the deed. The county civil courthouse was a building I had been in many times over the years, not as a party to anything, but as a researcher, pulling records, cross-referencing filings, the ordinary background work of a career spent in property title. I knew the parking structure, the clerk's window on the 2nd floor, the particular quality of light in the hallways in the morning. It was a familiar place to me. I suspected it was not familiar to Corinne. She arrived with her attorney, a man named Garrett, well-dressed, confident in the specific way of someone who has won enough cases to stop questioning whether he'll win the next one. Corinne walked beside him in a dark blazer, chin level, the composed expression she had worn at the board meeting. 2 board members followed at a slight distance. Derek was not there. Lisa and I were already seated at the respondents' table. On the table in front of Lisa, a portfolio, a pen, and a manila folder approximately 1.5 inches thick. On the table in front of me, nothing. I had brought nothing because I had nothing left to carry. Everything that mattered was already in that folder. Judge Patricia Chen took the bench at 9:03. She was in her early 60s, efficient without being brusque, the kind of judge who reads the briefs before she walks in and does not need to be told twice. She reviewed the case summary for approximately 45 seconds, made a note, and looked up. Garrett opened for the HOA. He was good. I'll give him that. He framed the matter as a straightforward enforcement dispute. A homeowners association with clear governing authority, a documented violation history, a lien filed under provisions the homeowner had agreed to when purchasing the property. He used the phrases well-established governance and community covenant and standard enforcement mechanism. In the first 4 minutes, he cited 2 comparable cases from the state appellate record. He was building something solid, and he knew it, and Corinne knew it. And she sat with her hands folded on the table in front of her, with the quiet satisfaction of someone watching a skilled professional do exactly what they were paid to do. Lisa waited until he was completely finished. Then she stood, opened the portfolio, and placed 6 documents on the table in a single row, left to right. She had numbered them Exhibit A through Exhibit F with small adhesive tabs in the upper right corner of each. Your Honor, she said, the HOA's entire claim in this matter rests on their authority over Maplewood Estate's common property. We are here today because the land the HOA's clubhouse was built on is not, and has never been HOA common property. It is private land owned by my client. She began with Exhibit A, the certified county assessor printout showing the current deed holder for parcel 7C. My name title chain unbroken from 1987 to the present. Exhibit B, the 1987 plat map for Maplewood Estates. She directed Judge Chen to the parcel designation for the lot on the southern boundary, the irregular half-acre at the geographic center of the neighborhood, private lot parcel 7C, not common area, Exhibit C, the purchase deed from March 1989, showing the acquisition of parcel 7C by narrator's father for $14,000 from the original developer. Exhibit D, the probate record from 2014, establishing narrator as sole heir to his father's estate, including all real property holdings. Lisa set the 4 documents side by side. The chain was clean, linear, and complete: purchase, ownership, death, inheritance, my name on the current record, 28 years of uncontested private ownership, sitting quietly in the county files, while a community association built their entire operation on top of it. Then she picked up Exhibit E. This is the 2001 construction permit for the Maplewood Estates clubhouse. In the lower right corner of the attached site plan, in the parcel designation field, you will find the following notation. She placed it on the bench copy stand. HOA Common Area Parcel 6D. She let that sit. Then Exhibit F. The deed record for Parcel 6D. 1 sentence of explanation. A green space on the north side of the development, correctly deed to the HOA in 1998. Never built upon. No structures present from 1998 to the present day. The physical location described in this construction permit the GPS boundary coordinates. The adjacent lot numbers, the utility connection points corresponds precisely to Parcel 7C on the 1987 plat, not Parcel 6D. The clubhouse sits on Parcel 7C. My client's parcel, she paused. Someone transposed 2 characters in a permit filed 23 years ago. No one caught it. The HOA has been operating a clubhouse on private property ever since collecting dues from 96 homeowners for 23 consecutive years to fund and maintain a building and amenities that sit entirely on land they do not own. And they filed a foreclosure lien against a 93-year-old woman without ever once verifying that the ground their organization stands on belongs to them. Garrett asked for a recess to review the documents. Judge Chen looked at him steadily. You've had 21 days, counselor, she said. Lisa continued, there is one additional matter the court should be aware of. She opened a second section of the portfolio. During the 23 years, the HOA has been operating on my client's land. The association undertook 2 significant capital improvement projects to the clubhouse facility, a renovation in 2009 and an expansion of the rear meeting room in 2016. Both were funded through special assessments levied on Maplewood residents. Total expenditure approximately $180,000. Under applicable property law, improvements made to private land by a party without legal title or recorded permission, generally attached to the land, meaning those improvements, as constructed, belong to the landowner. She set down the folder. My client owns the clubhouse. He also owns every dollar of work the HOA paid to improve it. The room was very quiet. I watched Corinne's attorney place Exhibit E in front of her. She looked at the construction permit. She turned to Exhibit I, the assessor printout with my name. She looked at the plat Exhibit B and found the boundary markings for Parcel 7C. Then she sat back. I had been watching people's faces across conference tables for 28 years. I knew what the moment of comprehension looked like, the specific sequence of it, the way understanding moves through a person when what they are understanding is something they cannot reverse. It starts around the eyes, a narrowing, then a stillness, then something deeper shift, and the expression that was there a moment ago is simply gone, replaced by whatever the person looks like when they are no longer performing anything. That was Corinne's face. The clubhouse where she had held every board meeting for 9 years. The building where she had signed every fine notice, run every election, built and maintained every mechanism of control that had made a neighborhood afraid. All of it on land she had never owned. All of it resting on a number that had been wrong since the day someone typed it into a permit in 2001. And every dollar the HOA had spent improving it. The new flooring in the meeting room, the expanded parking, the resurfaced pool deck, all of it legally attached to land with my name on the deed. She looked up from the documents. She did not look at Garrett. She looked at me. I held her gaze for a moment. Then I looked back at Judge Chen. Lisa introduced the remaining evidence methodically. Carol's sworn statement, $6,000 paid under duress. The email exempting Karen's own pergola from the process she had enforced against others. Inspector Watts's written assessment, 7 of 11 violations below standard enforcement threshold. Pattern described as disproportionate. The doorbell camera footage from the morning Derek taped the foreclosure notice to my mother's door at 7:14 a.m. without knocking, while a 93-year-old woman watched through frosted glass. The complete fine history for Unit 141 citations in 10 days, $1,990 commencing 3 days after the eviction notice. The HOA founding documents with their vague common area language, the precise ambiguity that had allowed a transposition error to persist for 2 decades unchallenged. 3 requests. First, immediate vacation of the lien. The HOA having no standing to encumber a property, while occupying land owned by the party they were encumbering. Second, a judicial finding that the HOA had been operating on private property since 2000, and one with an order requiring formal resolution of the title issue. Third, an order compelling the HOA to produce all financial records related to clubhouse operations and dues collection within 30 days for determination of appropriate restitution to the 96 homeowners who had paid fees for amenities on private land for 23 years. Judge Chen made notes. She heard Garrett's 3 arguments. She addressed the first 2 briefly. The third she heard in full, then shook her head once. The lien against Unit 14 was vacated, effective immediately. A full title hearing was scheduled for 30 days out. The HOA was ordered to produce all financial records within 30 days. And for the record, in the tone judges use when they want something clearly heard, the board's apparent failure to verify basic title before constructing a permanent structure raised significant questions about fiduciary responsibility, questions the court expected to be addressed at the full hearing. Garrett leaned toward Karen. I heard across the courtroom the word settlement. I leaned to Lisa. Tell them one condition is non-negotiable, I said. Mom sent. Francis stays in the garden. I don't care what else they propose. That statue doesn't move. Lisa looked at me for a second. Then she wrote it down. The morning after the preliminary ruling, I drove to my mother's house. It was early, just past 7. October light coming in low and sideways, making ordinary things look deliberate. I pulled into the driveway and sat in the car for a moment before going in. 31 years she had lived here. That cracked concrete path, those flowers, the wind chime on the porch. I had been coming to this house my entire adult life, and I had never once thought about whether she would still be here the next time I came. I didn't want to take that for granted again. She was already up when I knocked, already dressed, slacks, cardigan, hair done. She opened the door and looked at me with the expression of a woman who had been expecting me and had decided to be ready. She handed me a mug of coffee before I had fully crossed the threshold. Well, she said, settling into her chair, tell me. So I told her. Not the legal architecture, the outcome plainly. The lien was gone, permanently expuned from the county record. Every fine Karen had issued against this property. The wind chime, the garden hose, the handrail, all of it had been voided by the court. She was not going anywhere. She listened with both hands wrapped around her mug, watching my face. When I finished, she was quiet for a moment, and the St. Francis she said stays, I said in writing. Non-negotiable. It's in the settlement terms. She nodded once with the satisfied finality of someone who had known all along that was the only point that mattered. Then I took out the folder. I set the documents on the kitchen table between us. The plat map, my father's purchase deed from 1989, the current assessor printout. I walked her through it the way Lisa had walked me through it. The parcel number, the private lot designation, the clubhouse built on top of it in 2001, the transposed digit that had buried everything for 23 years. She listened without interrupting. She looked at each document carefully. When she got to the purchase deed from 1989, she stopped. She looked at the signature at the bottom, her husband's handwriting, the handwriting she had lived beside for 41 years of marriage. She touched it with 2 fingers. Was it your father who made this possible? She said in a way, yes, I said. She was quiet for a moment, then softly, "He always said that land was worth keeping." She looked up at me. I thought he meant the garden. She laughed quietly to herself, the way she laughed at things that were funny and not funny at the same time. Then she looked out the window at the scent. Francis' statue in the morning light. "He would have enjoyed this," she said. "Yes, I said he would have. I should tell you something I hadn't told her yet. I work in property title research. Have for 28 years. When I first spread those documents on my kitchen table and looked at that parcel number in my father's handwriting, I knew within 20 minutes what I was looking at. The chain of title, the plat designation, the discrepancy in the construction permit. It was not a complicated puzzle. I had solved it in the time it took to finish a cup of coffee. I could have called Karen the next morning, sent a letter from Lisa, and ended it in 48 hours. The fines would have vanished, the lien would never have been filed, and Karen would have retreated, blamed a predecessor's paperwork error, and survived to start the same cycle with the next family on her list. I chose to wait because the only way to make the reversal permanent, to make it impossible to walk back, minimize or quietly absorb into HOA administrative history, was to let them build their case completely. Let them file the lien. Let them walk into a courtroom fully confident. Let every notice, every fine, every threatening letter, every 7:14 a.m. door posting be on the public record before I laid down the deed. A reversal that happens in a lawyer's office on a Tuesday disappears. A reversal that happens in a county civil courtroom on the record with a judge's findings, formally entered that one, stays. I didn't want to stop them. I wanted them to stop themselves. The full title hearing came 30 days later. Judge Chen issued the final ruling on a Thursday afternoon. Parcel 7C formally confirmed as private property. Title vested in my name, unencumbered. The HOA found to have occupied private land since 2000, and one without legal instrument of any kind. Within 3 weeks, the new board Carol Ray's among them, elected at an emergency community meeting, signed a land lease for Parcel 7C, 10-year term, nominal annual fee, with 3 conditions I had written myself. No fine for any aesthetic item continuously present on a property for more than 10 years. All enforcement actions requiring a 2-3 board vote. 1 seat permanently designated for a Maplewood resident aged 70 or older. The new board's first official act was a written apology to every resident who had received a fine under Karen's tenure. Individual envelopes, specific acknowledgement of each case. Carol told me later it had taken 3 meetings to get the language right, and that getting it right had mattered to everyone in that room. The financial settlement came 6 weeks after the hearing. The HOA's insurance carrier declined full coverage after reviewing the title situation and enforcement history. The association paid from reserves $18,000 to my mother in restitution for fines, legal costs, and the documented distress of a foreclosure lien placed on her home of 31 years. Carol and 3 other neighbors had their contested fines reviewed and refunded. The HOA's operating account, padded for years by Karen's fine revenue, was significantly reduced. The fine machine that had funded the enforcement apparatus was effectively defunded. Karen and Derek both listed their homes within 90 days. They sold quietly in the winter without announcements. The bulletin board at the Maplewood entrance, where Karen had posted her community-wide compliance, notice had a handwritten index card on it the week after the final ruling, green ink. "Welcome back, Margaret." Nobody knew who put it there. Nobody asked. On the afternoon the last settlement paperwork was filed, I drove to my mother's house. No folder in my hand, no phone call pending, no deadline running in the background. She was in the garden when I arrived, moving slowly with the careful deliberateness of a person who understands that each thing worth doing is worth doing properly. She was deadheading the flowers along the front border. The same flowers 4 in beyond whatever line Karen had measured. The scent. Francis' statue sat among them in the afternoon light, exactly where it had been for 26 years. She looked up when she heard the gate. "You're early," she said. "I finished," I said. She looked at me for a moment. Then she looked back at the garden with the expression of someone who has been somewhere difficult and returned to find that everything they love is still there. I went inside and sat on the porch. No papers, no spreadsheet, no folder labeled Maplewood. Just the porch and the afternoon, and the wind chime turning slowly. The same wind chime that had started all of this. 11 years on that porch before Karen decided it was a violation. It was still there. Before I left, I went to the kitchen table and took out the eviction notice one last time. 4 pages. Karen's signature at the bottom, the 30-day deadline in bold, and placed it inside the folder next to the deed. My father's handwriting on the plat. My name on the assessor printout. The title changed from 1987 to the present. Clean and unbroken, exactly as it had always been. I pressed a yellow sticky note to the front of the folder. Parcel 7C resolved. I put it on the shelf in the hallway between a photograph of my parents at their kitchen table and a small ceramic dish my mother made in an art class in 1998 and never threw away. It looked on that shelf exactly like what it was, a document that had done its work and could now rest. I said goodbye to my mother. I walked back down the cracked concrete path. I got in my car. Karen thought she was removing a 93-year-old woman from a neighborhood. What she was actually doing without knowing it, without being able to stop it, was handing me everything I needed to give that neighborhood.